Hi everyone, my name is Sarah and this presentation will explore the impact of federal marijuana legalization on Indigenous communities throughout Canada. Here's a brief overview of how my presentation will be structured. First, I will provide some insight into the news story that first publicized some of the concerns that Indigenous communities are facing in light of this topic. Next, the issues and concerns presented in the news story will be analyzed in a historical context, a legal context, and in relation to other concerns that fall outside of these historical and legal scopes. Finally, a conclusion will provide some insights on where this issue stands moving forward. Recently, there have been several news reports published regarding the uncertainty surrounding the impact of Canada's federal marijuana legalization and how these laws will apply specifically on First Nation territory and reserves. The province of Ontario announced its plan to regulate and distribute marijuana through provincially controlled outlets, namely the LCBO. However, the plan was noticeably silent on how Ontario's Aboriginal peoples will fit into its scheme. A spokesperson on behalf of the Ontario government released a statement that the province will develop a government-to-government engagement process with Indigenous communities in order to ensure that concerns are addressed and groups are adequately consulted. However, Indigenous inclusion within multilateral conversations at the government level are being questioned already in relation to the legislation that is being written. This is largely due to the fact that many Aboriginal groups claim that the federal government already failed to include First Nations when developing its proposed legislation surrounding marijuana legalization, otherwise known as Bill C-45, the Cannabis Act. In a historical context, this form of governmental suppression has been taking place since the early settlement days, and throughout colonization, Indigenous governments were ignored or legally suppressed while the federal government unfairly imposed a number of Euro-Canadian political ideals on Indigenous societies. Thus, apprehension on behalf of the Aboriginal communities is quite understandable when it comes to new legislation creation at the provincial and federal level, so it is vitally important for these governments to recognize and respect Aboriginal governments and include them in their conversations. It is important to note that not all Indigenous communities feel the same way about marijuana legalization. Some groups have said they believe Indigenous communities, particularly those living on reserve, should receive priority access to the marijuana industry granted by the federal government, and many Indigenous communities want to see more opportunities to revitalize their economies beyond infrastructure such as casinos and tobacco shack sales. On the other hand, some Indigenous communities have expressed that they want no part in the legalized drug trade and that their communities should be granted the right to ban marijuana from their respective territories, as is currently the case with alcohol. In either case, provincial legislation must be careful to consider that cannabis is commonly used in traditional Indigenous medicinal and other health practices, and therefore restricting, inhibiting, or changing their already operating dispensaries could infringe on these rights. Many traditional health practices were repressed and banned during colonization, and even some historical missionary writings detail explicit descriptions of attempts to eradicate traditional healing practices in an attempt to assimilate Canada's Aboriginal peoples. Even today, many Indigenous communities heavily rely on their traditional healing knowledge, in part because of the unfortunate barriers surrounding access to government health care. While this issue extends far beyond the use of cannabis used for healing, the provincial government needs to ensure that it is not radically suppressing any traditional health practices by heavily regulating marijuana production and distribution. A 2014 Ontario court ruling found that Indigenous peoples have the right to their traditional medicines and to maintain their health practices, even if it involves the use of cannabis. A really great resource that I found relating to traditional Indigenous cannabis use is a podcast created by Real People's Media. I'll leave a link to this in the description of the video for anyone wanting to learn more about this topic, since it does stretch far beyond the scope of this presentation. As previously mentioned, some Indigenous communities would like priority access to the marijuana industry in order to benefit from its lucrative nature and its ability to help revitalize some of the Indigenous communities in need of an economic stimulus. Historically, the loss of land that Indigenous communities experienced as a result of colonization affected their economies in very detrimental ways. Ultimately, many Aboriginal peoples lost large parts of their territories and resource base to European settlers, and thus found it extremely difficult to maintain their traditional economies. Today, there are many continuing systemic factors, including social and physical factors, that hinder economic development for Aboriginal people in Canada. As we know, the regulation of business activity is quite complex on reserves. Thus, the federal and provincial governments need to be careful to consult and execute its legislation in such ways that would not impose any additional economic barriers on these communities. This is especially important since many could greatly benefit from the economic stimulus that the marijuana industry would provide. This ties into the notion that the federal and provincial governments are bound by Section 35 of the Constitution Act when regulating any activities on Aboriginal title land. So, this means that any infringement on Aboriginal title must be carefully justified, and this poses implications for any taxes imposed on the sale of marijuana, especially if those sales can be made on Aboriginal territory. Assembly of First Nations Ontario Regional Chief Isidore Day has gone on record to say that the provinces should have no role in deciding how Aboriginals will deal with marijuana on their territory, and he claims that the question regarding this whole matter is not about the provincial legislation, but whether Indigenous governments will be granted the permission to self-regulate marijuana or whether the federal government will be the regulator. Other representatives have said that Indigenous communities will take the exact same stance as they did with tobacco sales, and these reps claim that marijuana is a natural product, as is tobacco, and that their respective operations regarding marijuana should be left to Indigenous governments only. While it is still yet to be announced how provincial legislation, specifically in Ontario, will accommodate Indigenous peoples, it legally stands that the federal government has exclusive legislative authority over the on reserve status Indian population. The federal government could use this authority to create specialized programs surrounding the topic of marijuana legalization on reserves in order to help benefit the communities who fear that the drug may be abused or harm the safety of on reserve residents. Tying into these fears, some other considerations that are very important to note surrounding marijuana legalizations are the implications the drug itself may have on those communities. So many Aboriginal peoples in Canada have poor levels of education, health, employment, infrastructure, and income, and these distressing socioeconomic conditions validate why some Indigenous communities are fearful of what the implications of the legalized drug may have on worsening these conditions. So, some propositions to help mitigate these effects include revenue sharing agreements with the federal and provincial governments that will help offset some of the expected increases in costs for the communities on policing, ambulance, fire, and health services as a result of cannabis legalization. Other propositions include government funded health and education programs to help minimize the abuse of marijuana as a recreational drug, including overusage, impaired driving, and underage use. Conclusively, it is not too late for the federal government and provincial governments to ensure that thorough consideration is given to Canada's Indigenous communities when it comes to federal marijuana legalization. With opportunities to revitalize poor Aboriginal economies, preserve traditional health practices, and give Indigenous governments the voice and empowerment they deserve, the creation of this new cannabis legislation poses a prospect for ultimate inclusion of Canada's Aboriginal people, and it also stands as a gesture of reconciliation. Canada's governments need to be careful not to infringe on any of the rights of Aboriginal peoples when implementing such legislation, and proper consideration and consultation of these parties must be made for mutually content outcomes. This particular topic was quite interesting to follow, and I'm looking forward to seeing what taxation compromises and other specialized regulations the government will instill with regards to Canada's Aboriginal people. Being able to track the progress of this legislation journey is a privilege, and I believe the outcome of federal marijuana legalization and Canada's Indigenous communities will speak volumes as to our progression as a country regarding inclusion and fair treatment for all of our people. And with this, I would like to thank you for listening to my presentation.